Court rejects Nnamdi Kanu request to leave Sokoto prison. Sets new January hearing. This na CenokMedia, the channel wey dey report the news and dey make am simple for everybody to understand. We dey thank una when dey view us. Abeg, subscribe if you never do so. Put on your notification button. E go ring once we drop update. Make you like, comment, and share our video. My people, make una sit down well for this one, because the tori wey don land today for Abuja High Court get plenty weight, and e fit shape the next chapter for Nnamdi Kanu matter. Today, Justice James Omotosho don finally deliver im decision on the urgent request wey Nnamdi Kanu bin take back court to move am comot from Sokoto Correctional Center go Kuje prison for Abuja, or at least Keffi Custodial Center for Nasarawa. But the judge talk say no, not like this. Kanu no go get the transfer, at least not through ex parte application. According to the ruling wey happen this Monday, the court say Kanu bin file im request ex parte, meaning say he ask make the court grant am without hearing the federal government side. But Justice Omotosho say this particular matter get serious implications, and e no go good make court decide am without hearing all parties, because moving a high-profile detainee like Kanu no be small administrative decision. E concern national security, legal rights, and the logistics wey Nigerian Correctional Service suppose speak on. So instead of granting the application, the judge order Kanu legal team, this time acting through Legal Aid Council, to convert the request to motion on notice, serve am to the federal government and the NCOS, so everybody go get equal chance to talk their own. The matter don now get new date, January 27, 2026. Why the court reject the request? The judge explain say, look, this thing dey serious. You dey ask make we move person wey government say commit terrorism. If you wan run this kind of application, make everybody wey concern dey inside court. Meaning say the court no fit just carry inmate from one state go another without hearing from authorities wey dey manage am. The judge even remind everybody say last week, when Kanu younger brother show up for court, claim say he wan represent am, court no gree because the brother no be lawyer. Court want order, court want process, court want transparency. Kanu bin talk say he need to dey closer to Abuja so he fit prosecute im appeal properly. Im claim say the Sokoto facility far, and e dey strain im ability to follow up im constitutionally guaranteed right of appeal. But all that one go enter proper hearing on January 27 after government respond. Wetin this setback mean for Kanu? Even though e no be final defeat, e still be big stumbling block for the push wey im legal team dey do to move am back to a more central location, because right now Sokoto still remain the government choice. Tight security still dey around the prison, and from all indications, authorities dey extra cautious because of the sensitivity of the case. So as the matter dey now, Kanu no go comot from Sokoto. Nothing change for im physical location. The fight don simply shift go January hearing. Some security analysts dey talk say leaving Kanu inside Sokoto fit be deliberate strategy. Distance dey reduce spontaneous protest, e dey reduce pressure, and e go keep am away from the region where im supporters dey plenty. This na the first major move wey Legal Aid Council dey front for Kanu matter. Analysts dey ask, why Legal Aid Council suddenly dey involved? E fit mean say independence wan show face, since Kanu dey insist say he wan represent himself, or na backup plan in case im personal lawyers no dey aligned. Even if Kanu relocate, e no automatically change the appeal court attitude, because the real limitation no be location, na legal strategy. Moving him nearer no guarantee faster appeal. Some insiders dey argue say setting the hearing for late January fit be the court way to buy time, considering the tension around the case, the holiday period for judiciary, and the heavy-duty security planning involved for any transfer order. One fresh way to look the matter na say Justice Omotosho dey send strong signal to the public. The era of shortcut applications don end. By refusing the ex parte request, the court dey try restore confidence say big profile cases no go get special speed or special flavour. E fit be subtle judicial message say rule of law no dey bend for anybody, not even for Kanu. Dis one dey subtle, but e dey there. Federal High Court judges dey under pressure from government on one side and from public scrutiny on the other side. The refusal to grant this request silently shield the judiciary from future accusations like una move am because una biased. So this decision fit be defensive move. Protect the bench before anybody start pointing fingers. People no dey think am this way, but relocating Kanu no be small operation. Security teams, convoy, air surveillance, correctional manpower, route coordination, all of them cost money and require clearance from multiple agencies. By refusing the ex parte request, the judge indirectly avoid forcing government into emergency security deployment wey no dey pre-planned. In short, the ruling saved the system from a rushed, expensive and risky transfer. Relocating Kanu to Abuja or Nasarawa fit flare up political tension instantly. Court fit dey read the mood of the country and intentionally dey slow things down to avoid sudden spike in demonstrations, online agitation and political misinterpretation. So this delay fit be soft cooling strategy to allow government and security agencies brace themselves. Another angle na say Kanu team miscalculate. They assume court go see the distance from Sokoto to Abuja as valid reason for urgent relocation. But the judge flip the script. Distance no be legal emergency. Your right still dey intact even if your prison far. So instead of fast-tracking the relocation, the ex parte request actually slowed the process. This moment fit force Kanu team to re-strategize, maybe bring stronger medical evidence or stronger constitutional argument for next hearing. My people, as this matter stand now, one thing clear pass any other thing. The road ahead not straight, and the court don purposely slow the pace, so everybody go show their cards for open. January 27 not just be another court date, e go be moment of truth. Na that day we go know whether Nnamdi Kanu fit return closer to the center of power or whether the system go insist say Sokoto still remain the safest place to keep am. And make we not deceive ourselves. Everybody dey watch this case. The politicians, security agencies, international community and millions of people wey believe say how Nigeria handle Kanu fit define the future of legal fairness for this country. So as we dey move toward that January hearing, the tension go rise small small, the arguments go sharpen and the stakes go climb higher. But no matter how the story turn, no matter the decision wey land, one thing sure, the truth of this matter no fit hide forever. The system must answer, the court must decide, and history must record how Nigeria handle one of our most sensitive cases. My people, make una hold this channel well, because when the next chapter open, we go dey here, steady, balanced, and ready to break am down for una the way only CenokMedia sabi do am. Stay close, because the real tori never even start.